Okay.
Okay, we are recording.
Okay, so I'll go ahead and call the meeting to order. Today is the May 8th, 2024 meeting of the City of San Diego Commission on Police Practices Ad Hoc Committee on Operating Procedures. And our agenda today will be to make a couple of minor changes to our final complaint operating procedure, to review the pitches motions and subpoena operating procedures. And I see that Olga had a couple of questions or comments that we'll address. And if time permits, we'll get started on the case review procedures. And so we may or may not get to those depending upon how long the others take. So let's start with the complaint procedure. And do you mind putting those up?
The complaint procedure, or I thought we were doing pitches and subpoena.
Well, there's a couple of things we need to go back on the complaint procedure on, and then we can do the pitches and subpoena. So
okay,
it should only take a couple of minutes.
Okay.
The first one was, as requested at the last meeting, I checked with Dwayne to see if he was okay with, scroll down to where it says forms, and I think I put a note there where I added what he suggested.
Oh, I'm in the other document, so I'm in the final draft document.
Well, you can just stay in the final draft document.
Okay.
Maybe I put in the wrong one.
I believe this is where you're.
Let me see. It was yes, and so after Penal Code Section 148.6, he suggested that we put as required by law. And then if the law doesn't require it, then we're not required to.
Okay.
And but other than that, he was okay with us not putting it. And actually, when he learned that the language could be changed, he thought it was a good idea to not include it, so we wouldn't have to go back to be to confer if they did change it. I think that bill is dead, but it doesn't mean that there won't be another subsequent change to it, because it is problematic. And then Olga noticed, I think, go all the way to the end, I think, that what we have in the investigations procedure and what we have in this document, I think it was the very last sentence, wasn't it? Maybe I could be wrong.
Yeah, so it was removed from this document, but it is in the investigations procedure, this one.
Oh, okay, so you're putting both of them up, okay.
Mm-hmm.
And so we probably need to be consistent. So you have the investigation procedure up run right now, correct?
Yeah.
Okay, and it says where a third-party complaint is not investigated because the impacted party does not choose to file a complaint, the third-party complainant should be notified as such. And I think we had that in the first draft of the complaint procedure, and we had a discussion and we decided to remove it. And to be honest, I can't remember what the rationale was. Maybe one of you do, but Clovis, do you recall why we didn't include that in the complaint procedure?
Okay, it didn't include which part? You lost me.
Okay, so in the investigations procedure,
right,
we have a sentence that says when a third-party complaint is not investigated because the impacted party does not choose to file a complaint, the third-party complainant should be notified as such.
And so we have that. You say we have that in investigation, but not in the complaint procedure. Is that what you're saying?
Yes.
I would have to
I don't recall. I think we were doing that towards the end of the meeting, and
yeah,
we were kind of scrambling.
Yeah,
So
there was a lot.
Yeah, I don't exactly recall the rationale for removing this piece either.
Yeah, because I think the idea was because we as the commission have the authority to investigate certain things irrespective of whether or not there is a complaint, that we didn't want to have a complaint shut down just because somebody wasn't complaining. We do have the requirement that if somebody says they do not want something investigated by the CPP, if we have no other complaint, no other, I guess, inroad into it, that we have to abandon it. But I think we were talking about that we wanted to make sure that we had the opportunity to investigate something, even if one of the parties either didn't cooperate or withdrew their complaint.
Right. And would this language necessarily preclude that?
No,
Because-
this is more for notification.
Right.
Right. So I think this one was, I put it in there on purpose, just in case there's a third-party complainant who files a complaint and there would be no one who participates, and basically the investigation ends up with no investigation. So in that case, it would be appropriate to let the third-party complainant know what was the outcome. But I think the rationale is that the complainant, regarding of whether they're a third-party complainant or an actual complainant who experienced the conduct, is entitled to notification of the outcome of the complaint. So I think, and now I'm remembering as I'm saying that. So this kind of then maybe is contradictory in a sense that regardless of third party, first party complainant still will know what would be the outcome of the complaint. But the main thing is that they should not be provided with any confidential information.
Okay.
And
Oops.
this is the
For
one
some
that
reason,
we're
I just
keeping. So no, I remembered why we removed it. And this just has to do with notification piece.
yeah. So I think that we removed it because we wanted to have the option of investigating a case, even if the impacted party didn't choose to. But this does not preclude that. It simply says that when we choose not to investigate because the impacted party doesn't choose to file a complaint, then we would let them know.
Right, and we just say that at the conclusion here, at the conclusion of the investigation, the commission will notify the complainant, basically regardless, right, of the outcome.
Yeah.
So I think this is now redundant because in this scenario, the third party complainant will know
Yeah.
that the investigation didn't happen or
Yeah,
whatever
it
the
does look
outcome would
redundant.
be.
Yeah, I agree.
Okay, you're saying it's redundant of another thing in the same policy, or?
Yeah, so we have the provision that at the conclusion of the investigation, the commission will notify the complainant, right, impacted party and subject officer of the outcome of the investigation.
Okay.
There's really no need then to specify what will happen with a third party complainant because they are a complainant and they will get notified of the outcome of the investigation.
Okay, so we probably need to remove it from the investigations policy, but since it's already been approved by the commission, we probably should put it. No, it's not to put it on the agenda. I can ask Gloria to put it, because the agenda doesn't go out till Friday, so I can ask her to put the investigations policy on the the investigation policy on the agenda as well. And we can maybe just include that one paragraph, or maybe I'll even just suggest that you put on the agenda, remove the sentence blank to be consistent with the complaint policy. Yeah, and that way you don't have to put the entire document in the whole agenda.
Do you think it would be appropriate first for the commission to review the complaint procedure and vote on it because they will see it for the first time in the next meeting, I'm assuming?
And so do the complaint procedure first?
Yeah.
Yeah, we can do that. And then maybe, I wonder if there's a way that we can do it as part of the approval of the complaint procedure.
Mhm.
Um, and, except that this is not going to be in the complaint procedure. So the, um,
Maybe we're overthinking it. Okay, it's redundant. Who cares?
Right.
Right,
Can we
Meg?
remove it when it goes to the meet and confirm and then just say
Yeah.
we strike the sentence, we changed our mind? I
Yeah.
don't know.
I mean, if we got to go through all this just to get one sentence taken out of this one document, maybe it's. I mean, it's just redundant. So what? Okay, it says the same thing. If they look at it, they want to take it out, that's fine. But I think we're kind of going through serious machinations here for one sentence. That's
Yeah, yeah.
although,
And again, the only reason I flagged this is that I remembered when we started going through the complaint procedure, I remembered, oh, wait, we have this sentence that we removed from the complaint procedure from the investigations procedure. I'm not necessarily sure, what would the proper be process to address this, but I just flagged it for Doug to see if we want to do anything about it or if we need to do anything about it.
yeah, well, actually, my concern about leaving it in is the same concern that we had when it was in the complaint procedure, is that it could be interpreted as saying that if the third party um, if the impacted party doesn't want to proceed, but the third party does, and it's a real clear violation, that we should have the ability to
yeah, to go ahead and do our investigation, even if we don't have a complaint, an impacted party, if and we still have a complainant.
okay, then why don't we do this? Why don't we, because if you could put a note on that
Mhm.
and put recommend a removal of this sentence, and but I do think at some point we will probably need to get the commission to approve it rather than just wait for the meeting and confer,
Mhm.
because because I'm not sure that Dwayne has the ability to take things out on his own, and I don't think that the POA will want this taken out because they so okay, then let's not deal with it next week, but we may we may have an opportunity down the road to do some cleanup with all the
Mhm.
policies, and we can because after we have our new executive director, he or she may have some concerns, and Danelle is suggesting that we spend some more time making sure that all of our I's are dotted and T's are crossed and so forth. And so we may come back to the commission with some cleanup. And so let's just leave it there for cleanup.
Okay, and it is in the final documents folder. I created a separate folder in Google Drive, so all the final procedures that go through the committee and then the commission's approval are in this folder, so that we know those are the final documents.
Do they enter the folder before or after the commission votes?
After the commission votes on them. So-
Okay, yeah, so that's why I didn't realize or remember that, and so I was looking at the other document when I made the change today. Okay, so that's a folder within the ad hoc committee's folder.
Mhm, yeah.
Okay, then let's go ahead and go to let's do the subpoena one first.
Just to confirm, were there any other changes or issues for the complaint procedure, or this is good with that one amendment as supported by law?
Yeah, so I think we're good.
Okay.
And so we can move that one.
Okay, sounds good.
And then let's do the subpoena one. Yeah, I do know that the process for serving people that's part of California law. I've been involved in some of that in the past. And the but yeah, so that is a legal requirement. And so I
So
would,
could you explain, I don't know if you have the answers, but serving the subpoena, what is exactly required by law?
well, there's a
Do you
couple of
know?
there's a couple of different options. It can be served in person, and there's certain things that they have to do. The person has to be 18 years old, they have a certification process. There's a process if the person isn't available. So I think they can like try 3 times, and then they can like post it on the door, I forget exactly what all of them are. But there's also a process of being able to do it by mail. And it doesn't say certified mail service, but you have to be able to prove that you mailed it. So that would be the same thing as certified mail service. So I guess I would leave that in because I know that that those are the processes for serving court documents.
So the court documents, yes, but the subpoena isn't a court document.
Um,
The CPP subpoena is not going to be a court document. And the only reason why I'm flagging this is that I'm looking at it from like the operational perspective, how things will be done like on the ground. So and again, the only reason I'm flagging it, if it's actually a legal requirement or not, because there are other ways to serve a subpoena. You can just bring it yourself in person, most common ways to mail it, right? But you don't necessarily need, for example, in New York City to use a process server to
Well,
deliver a subpoena that's
Well,
like just a regular subpoena for evidence.
okay, well, and I don't think it's we put preferably there. Well, we can submit a question to Dwayne to see if because you're asking a legal question and I'm not an attorney, and
Right.
so
And I'm happy to also do research in this and see if it's actually a legal requirement. But I can ask Mr. Bennett as well.
Didn't Mr. Bennett not write this doc? Keep trying to scroll.
he wrote
screen. Yeah,
He
didn't
wrote-
you write this? Yeah.
Well, he wrote it, but we can ask the question of whether or not it's a legal requirement.
Right, and he wrote it from the perspective of the lawyer, and I'm looking at it from a perspective of investigator who has been doing that for 7 years. And I know that certain things can be done different ways, so he may not necessarily know the issues like on the ground that can create kind of just logistical barriers. If it's not really required, then
Okay,
I wouldn't recommend specifying that.
Okay, and I'm just thinking in terms of timing, because we have to get this document attached to the agenda on Friday. So if you're able to get an answer from him before Friday at noon, Clovis, are you okay with authorizing her to make the change per what Dwayne says?
Certainly.
And if he says that it has to stay the way that it is, or if we're not able to get an answer, then we can put it on the agenda as it is. And if we get an answer after Friday, and we want to modify it, we can make an amendment when it comes up for the agenda. Okay.
On the agenda for the commission, yeah.
Right, and so we can make a motion to and we could be prepared for that too, so we can actually, show this is what we're recommending based on a question that was asked of our legal counsel. Okay, then let's move down to your next one, which I thought made sense. It had to do with, and that's all part of the same thing. There was one where I would think you would need the date and time if you're going to give a subpoena for an personal appearance. Yeah, so why don't we just add that? They
the following location, address.
And just put maybe a date and time, because they're not, they can't just show up anytime. And that probably is an oversight. Okay, let me take that off. Yeah, so there are several, there are several references to interim executive director, and they have Charmaine Mosley's name. I don't know why he did that. You don't want to put a person's name in a operating procedure because that person may not be with us. And so I would say that everywhere where it says interim executive director, we changed it to executive director. And everywhere where it says Charmaine Mosley, we removed Charmaine Mosley and put bracket name bracket.
So I was flagging that, I also for another reason, so not necessarily, I mean, obviously, yes, we should remove the name. But I was also suggesting to not even specify the position of the person.
Well, yeah, I'm sorry, I missed that. But I'll still go back and say what I just said. So anywhere in the document where it says interim executive director, we change it to executive director, and where it says Charmaine Mosley, we put name. And then for what you're suggesting there, I agree. Says if you have questions regarding the subpoena, contact, and then put name and name, title, phone number.
Right.
Yeah,
Do we need
name.
to get into that specific? Should it not just reference the authority, because the executive director may appoint someone else as the authority to do that?
Well,
Should
that's what Olga's saying. And so instead of saying the person, to just say, if you have any questions regarding this subpoena, contact, and then take off interim executive director Charmaine Mosley, and simply put name, position, and contact info.
Is it too broad to simply say Office of the Commission on Police Practices?
It is too broad just because, again, in practice, when people receive, and that's just me speaking from my experience, when people receive a subpoena and it will say executive director, they will reach out to the executive director, and the executive director will have no idea what case this is about, what this is about. So typically the investigator's name or the investigative manager's name goes in the subpoena because they're able to then speak to the person and tell them, if you can't come in, these are the other ways you can comply with the subpoena, or if you can't mail the evidence, you can bring it in person, etc.
Right.
So this is, again, simply kind of just logistical observation, which
Okay.
is better from the operational standpoint.
Okay, does
So
anybody have a problem with deleting what's in highlighted and put bracket name, position,
Oh, okay. Gotcha.
contact information? Yeah,
That's what I'm suggesting, yeah.
yeah, because it might even be the general counsel.
Yeah, it could be, yeah,
Right.
because I'm thinking that's for investigative perspective, but there will be absolutely subpoena sent for other things, and it should be directed to
Yeah.
the person who's, who will be responsible for addressing the subpoena.
Okay. Gotcha.
Contact information, name, title. Contact information, and here, Doug, you were saying, this should say executive director, right? The person who's issuing the subpoena.
Right.
No, not the name, and this will be the field for the name.
Yeah, and can you do a global search, and everywhere we have Charmaine's name, we can put the bracket name, and everywhere it says interim, we'll take out the word interim.
Yeah, and is it okay if I do it after the meeting? So I just don't want to spend doing that right now.
Absolutely.
Okay.
Yeah, see, and I think and I think what we have there, I think, is what if you use a that I think is the form that I think you have to have, because you have to have the proof of service. And so and this is what, scroll down to, let me see if it lists all of the if it lists the by mail, by overnight delivery, and then see if there's a personal one. Oh, I see. He,
What about electronic like DocuSign?
I think that a subpoena has to be given in person. In other words, a document you have to send, you have to send, oh, I don't think you can send a subpoena electronically.
And again, that may be me not knowing California law, but in New York, you can totally do that.
Then let's,
But but again, I'm not talking about court subpoena, like this administrative subpoena, you can totally do that.
okay, then I don't know, and it basically the same question. And so
Mhm.
why don't we you know, and it's not it's not a requirement that we have all the forms in our procedure, but it's a good idea. And so why don't we wait for Olga to find out what the service requirements are, and you know, and we'll treat it just like the other one. So if it's not necessary, we will not include it. If it is necessary, we'll include it. And if we don't have an answer by noon on Friday, then we will include it, and we will amend it if we get direction from our legal counsel prior to at the meeting that we could do that.
Mhm.
Okay. And I think the rest of them were all along those same lines with either
Yeah, so here it says, this is a little bit different. So this one, yes, we can change the name, title and date, and this would be, sorry, contact information, this would be removing the name. There's two different questions that are not necessarily what we just discussed. So this one is, this is subpoena, this is Tigum, I don't know how to properly pronounce it, but this is the one where you request evidence as opposed to somebody's personal appearance. So it is pretty specific how you are requesting the documents to be produced. But I think, again, it's limiting some other options. You don't necessarily always need to mail things. You can just email them. You can bring them in person. And again, I'm not sure if this is like a California legal requirement to include that specific language. Because I think it's, again, it's limiting options.
You're right. It doesn't say
Sometimes it's just as simple as emailing
it doesn't say you can do it in person, and I'm sure you can do it in person.
Right. Together with a certification from you, dated and signed.
Okay, and so if you don't mind including that in your question for Dwayne, although I'm not sure, well, and actually it may be possible to comply with that electronically as well. And so, yeah, that's a good question.
Because I would just kind of simplify it by mailing or other.
I'm not hearing you.
Hmm?
And I don't know what's going on here. Oh, I know what's happening. There you go. I think can you speak again?
Yeah.
Say something.
Yes. Hello.
Oh, I'm not hearing you. I don't know what's going on.
Can you hear me, Doug? I guess he's not
Yeah,
hearing
it
me.
doesn't. Yeah, it doesn't look like you can hear us.
I can hear you. It sounds like you can hear me. I'm glad to know. Well, I'm not glad to know, but I've had just incredible trouble with Zoom the last few days. So maybe it's a Zoom thing. And now we can't hear him either.
I'm just silent. I'm typing.
Yeah. Can you hear? You can't hear Doug either. Can you hear Doug?
No. Name, title, content.
Yeah.
I'm just going through the edits. Name, title, contact information.
The Bluetooth.
Okay, can you hear me now?
Yes, sir. Can you hear us?
Okay, yes, I took off my headphones altogether, and so it was something to do with my headphone, but I don't know what I did. So I'm just going to, as long as you can hear me okay, I'm just gonna leave my headphones off.
Yeah, you're loud and clear.
Okay.
Okay, so yes, I will ask Mr. Bennett this question, and then there was I'm sorry, another question that I had. Let me just center this one. This is about notice for interview, which will be sent to the officer. Again, I think it's the same thing, is not specifying
Yeah,
the executive director, just saying again, name, title, contact information.
Right.
Are you okay with changing that?
yes,
Okay,
we'll do that, goal boy. So I guess so the two questions that we have of Mr. Bennett are, what are the legal requirements for service? And what are the legal requirements for, or what are the legal options for providing documents?
Mhm. Yeah, okay, let me write that down because you said that very concisely.
Unfortunately, I don't think that Dwayne will give you a concise answer, but
Yes. Subpoena and legal. Providing, may I just kind of just throwing it out there, again, I don't know when we'll receive a response, but in case we receive a response and we feel like we want to discuss this issue more, may I suggest that we just move the subpoena procedure to the next meeting, or you do want to bring it up to the meeting on the 15th?
well, that's another option, because it's not critical now, since we're giving ourselves a little bit more time.
Right,
And so we can move it to the next meeting if we need to. So how about if we don't get an answer by Friday, then let's just take it off of the agenda.
okay.
That would probably be simpler than trying to amend it in the meeting, because
Mhm.
Yeah.
people get confused.
Yeah, because we need to then also figure out the language, and I think it's gonna be just too complicated.
So considering how compressed our meetings are already, should we just take this off of the next agenda, period, and consider it for a later agenda item and not even have it come up at this point?
Well, I'm kind of assuming that the commission is not going to get into the weeds on the legal procedures of the subpoena and the Pitch's motion.
I'm willing to bet they won't get into the Bridges motion, not into the weeds on that one, but okay.
And if they do, then, and it takes too much time, then we can always
Yeah,
make
table
a
it.
motion to and then we'll do the complaint procedure first. And Gloria allowed us 45 minutes. It doesn't have times on the actual agenda, but we have a working agenda that has times. She allowed us 45 minutes.
Okay.
And I told her it may or may not take that. It's hard to predict, whether the commission will get stuck on an issue, or whether or not, when we did the investigation procedures, they had like a couple of questions, and we got that approved in less than half an hour, but we'll see.
All righty, sounds good.
Okay,
Okay,
then
so this one, closing this one,
I'm sorry, what did you?
subpoena.
I'm sorry, I didn't understand what you just said.
I'm saying, are we done with the subpoena procedure? Am I okay to close this document?
yeah, I think so.
Yep.
Okay,
And then and I may not be around on well, no, actually, I'm not leaving the office until noon. I'm not going to be available after noon on Friday. But if you can let me know, and
let Danelle know.
Mm-hmm.
Who does who does the actual agenda and sends it out? Is that Danelle? Or
Alina,
let me just let both of them know, and I will let after this meeting, I'll let Gloria know that we're waiting on a legal answer, and we may pull it from the agenda and do it at a later meeting if we don't get the answer by Friday at noon.
okay, you will give her the heads up, are you
I'll
saying?
give her the heads up, yeah.
Okay,
And then if you can, well, the complaint procedure will go on there regardless.
Mhm.
And if we need to remove either the subpoena or the pitches motion because we need a legal answer, which we don't get by Friday, then we'll just take them off of the agenda.
okay. That sounds like a plan.
Yep.
And so first question, I think was in like in the first paragraph you had. Well, I forgot to ask you, so was there any questions on the subpoena one, but I assumed you would have spoken up if you had.
You are correct. I would have spoken up if I had. No, I didn't have not any additional questions.
I've never known you to be shy. So go back. Oh,
Sorry, I'm just scrolling to see if there are any questions there. I think this one. Yeah, I just had one question.
and it says copies of records. My guess, and I'm pretty sure about this, is that it should be the same as, because it says, the first sentence of the section says it is required by the Commission on Police Practices to maintain the confidentiality of police personnel records, complaints against officers, and information obtained from, etc. And so my assumption would be that it should say copies of police personnel records instead of just records.
Mm-hmm. Yeah, because that was my concern, is like all records or
I mean, the police department should not get Olga's evaluation records.
right.
Internal thing that don't relate to them. So I'm 95% certain that that's what it is. So let's put police personnel records before, or copies of police personnel records.
But is it just personnel records?
Well, that's what it deals with. If you look at the first paragraph,
That's right. This is Pritchard's. Okay, so yeah, that makes them. Yeah.
yeah, and that's what a pitches motion is.
Right. Right. Yeah.
Mhm.
And so I think that's a good call. Otherwise, they could say, well, we have access to everything, which would be an overstep of the department. And was
Right.
that the only substantive question you had?
Yeah, that was the only question I had.
Okay. And what about you, Clovis?
Nope. I just was following that very same lead. I figured it's all boilerplate legal stuff that we don't have much choice about.
Okay. Then how are we doing? Well, we're actually doing good on time. So and hopefully, Clovis, you've had a chance to look at the case review procedures. But if not, we can go through them section by section.
Case review procedures.
So sorry, can we just pause for a second on this one? So the pitches motion, it just requires a little bit of formatting and editing, and I'm happy to do that because it's just not, like fonts are not consistent and stuff like that. So I can do that and move that to the final folder and then send it to you, Doug, both with the complaint procedure. Or I
Okay.
can send it to you and Gloria in that general email if you'd like, or whatever your preference is.
Well, I trust you to format it correctly, and so I'm not going to spend time looking over after you send it to me. So why don't you just send it to well, actually all you need to do is send it to Alina and Danelle,
Mm-hmm.
and then subpoena one, if we get those answers resolved by Friday, we'll put that on there, and if not, we'll consider it at a subsequent meeting.
Okay, sounds good.
Okay. And then I don't know whether Clovis, you had a chance to look at the wonderful job I did on the case review procedures.
I did. I have glanced at them previously. Have not looked at them recently. I just looked at purchase and subpoena for this meeting.
Okay, that's fine.
Did I miss, was I remiss in not having taken a look at the
No, I
case?
think that's fine. I think we decided that if we got through this, we would start on this procedure. But we can go, it's actually not that long. We probably won't get through it by 7 o'clock, but we can get a good start.
Okay.
And so if you can pull it up.
I'm just trying to find which version it should be. Because there's two versions.
Does it show a date?
I'm trying to see. One is April 24th and one has your notes today, April 26th. So I'm guessing it's this one. And I see you having this document open, so I'm assuming that's the one.
Okay. If it's not, I'll probably recognize it when we get there. Okay, and you can make it a little bit bigger.
Sorry, always a challenge for me. Okay.
Okay, and so this was, I modified it based upon the feedback that we got from the commission a couple of meetings ago. Wait a second, is this you got, this is a complaint procedure.
Is that the complaint procedure? Oh, yes, I
Yeah.
apologize.
Okay. I was a little confused too. Thank you.
Oh. I investigation. I think it's this one. I'm opening updated proposed operating procedure for review by investigations version 2 from April 24th. I'm
Yeah,
opening
that probably is
that
it.
document.
Okay. Good. Scroll down and see how many pages it is. I forget how many. It's not that long.
It's 3 pages.
Pages, okay. And so we'll just get through it.
I think I had some notes there as well, but I don't know if it's in this one or not.
Okay. Well, so it's only 3 pages. This is go through section by section. And we'll do that for the next 20 minutes. And if we don't get through, which we probably won't, then we'll do it at our next meeting. Okay, so the first one is just the municipal code section. So scroll down.
Sorry, give me one moment. I'm just opening the document where I had my notes so I could have it
Oh, okay.
for myself. Okay.
Okay. Why don't we just each read the paragraph and then we can indicate if we have any issues.
Mm-hmm.
And just as a note, per the desire of the commission, this procedure applies to both category 1 and category 2. So it mentions category 1 and category 2 only because there's a difference of how the department handles it, of who investigates it. But this procedure does not make a distinction between category 1 and category 2. They'll be treated the same.
So we have run into situations where the AI investigator did not thoroughly investigate. I'm looking at this last paragraph. The investigator's report, including all the findings and all related material to STPD investigation file, are forwarded to the commission. And I'm wondering, do we want to strengthen that to say that, because we've asked sometimes for material and we've been refused. I think there was one time when we were reviewing a case, there were missing reports or body worn camera or something. we weren't sure whether or not they would shed any light on the investigation, but they were missing, and the investigator had not reviewed them. And then we said, well, what happened to this? And he said, well, and, we asked the question, what happened to this other information? He went back and found the information and then said it wasn't relevant. I'm not giving it to you. So do we want to
Is it-
strengthen this to get that kind of information out of them, irrespective of whether or not they think it's relevant?
Well, I think that's how I would interpret this sentence. It says the investigator's report, including the findings and all related material in the SDPD investigation file, are forwarded to the commission.
Yeah, but what about stuff they don't put in their investigation file?
Um,
They don't think they don't think it's relevant, and they don't put it in. So, and then they come back and say it wasn't relevant to the investigation as far as I'm concerned. So you can't have it.
Well, I guess, that also then, that kind of, I don't think we have an option there, because if I didn't consider that as part of their investigation, then the commission technically shouldn't consider that as part of its review either. I think it's different for investigations. Then the commission obviously would want to request all the documents and due diligence when the commission is doing their own investigations. But for IA, if they didn't use that it's a matter of them then not doing a thorough investigation.
I mean, we
Which
could do it.
should be addressed separately, but not.
I guess we could word it one of two ways. One is to say all related material reviewed by IA, or we can simply say all material in the investigation file. And so, like in the example you gave, Clovis, I would think that those body-worn cameras would be in the investigation file, even if they didn't. I think what the department is saying is that if we don't use it in our report, we're not going to give it to you.
Right.
And this is saying that if you have it, you have to give it to us. And that's why we underlined all.
And so the follow-up to that, if they don't have something, is for us to actually do our own investigation and ask for it.
If it qualifies for doing our own investigation, but and we get that later.
Right. Yeah.
But it's
Or I would say point out that, like how we are doing concerns in the case review reports, if commissioners believe that an investigator should have looked at that evidence, then also pointing that out as part of the feedback, that in this particular case, you believe that an investigator should have also considered that as part of the investigation. So I think that would be the other way of doing that.
Okay.
then let's go on to the next page. Uh, Okay, so the first paragraph is basically a summary of the first part of our investigations.
Mm-hmm.
Okay. And then the next paragraph, maybe I'll explain why it's worded the way that it is. We wanted to make it flexible so that in the future, who does the reviews, it's kind of up to the commission to decide which method works best and what resources we have available. And so it could be done by a group of commissioners. It could be done entirely by staff, or it could be done by a commission, a combination of commission staff and one or more commissioners. And then we were referring to them now as reviewers instead of teams. And so this gives us the flexibility. I mean, we can continue doing it exactly the way we're doing it now. Probably without in the long term. Well, I don't know. anyway, it gives us the option of whether or not the reviewers are going to be entirely commissioners, whether they're going to be commissioners and staff, or entirely staff. And also I think it implied in that too is that if it's commissioners and staff, staff could be assigned certain roles. So staff could be assigned to, for example, draft the report, or to do certain preliminary review prior to the team doing it. But anyway, the intent of the second paragraph is to make it very flexible. Any
I like it. Sounds good.
And even looking at that last sentence there, I think that reinforces what we were saying previously. It says the reviewer shall have access to all materials used by EIA in the course of their investigation. Okay, now here's the issue which is kind of related to the question you just asked. It says that if during the course of their review, the reviewers make a determination that an independent investigation of one or more of the allegations to be warranted, a recommendation for an independent investigation shall be sent to the executive director and chief investigator. The cabinet, in consultation with chief investigator and executive director, determines that an independent investigation is not warranted, or that there is insufficient time to complete an investigation within the time constraints specified in POBAR. The case will be returned to the reviewers for findings. So we wanted to have an option that if the team or reviewers see an issue with the case and they think that because of that issue, there should be an independent investigation of one or more of the allegations, that would be an option. But making it clear that depending upon when that determination is made, or depending upon when that determination is made, and B, the resources that we have in terms of investigators, that request may or may not be feasible. Does that make sense? So I wanted to have some option there, so because I think it's quite possible that you would sometimes see that IA just missed the boat here and we need to do our own investigation. And then maybe not be something that was obvious when the case first came in and they looked it over and decided we want to do that. So thoughts about that?
I like that. I'm curious. I would assume that such an investigation would be fairly rare. And it hasn't come to my mind what circumstances might cause us to feel, and I think it's very interesting that I think that's why we exist as a CPP instead of CRB, is what circumstance might we, I'm just trying to anticipate and think, right? Especially in terms of potential arguments from the BP, the POA and the other commissioners. What kind of scenario might we consider doing an investigation?
Say that they did not interview the key people. And so there were eyewitnesses that they didn't interview, or so I guess it would be that we found that the investigation was not thorough, or that the conclusions were misleading, and we wanted to interview people ourselves, for example.
So thinking about the cases we've seen so far, I'm thinking of a couple of cases already where we would have, based on that, we probably would have wanted to have our own investigation.
Right, but keeping in mind that it has to fall within the categories of independent investigation. So there's like 5 different categories. It has to be. Are you pulling them up?
Yeah, are you seeing that?
Yeah.
Yeah,
Type
so,
of
right.
incidents. Yeah.
So these are by default, but these are the other categories that the commission has discretion.
Yeah, and so
Okay.
so it would have to be
Oh, okay.
So it has to fall within one of those. And so if it's just like a routine case that doesn't fall within there, then we couldn't do it. And I
Okay.
think if I didn't, I probably should include the wording, if we can go
Mhm.
of uh,
Somewhere here. Allegations. That fall within,
yeah, so maybe instead of one or more of the allegations may be warranted.
that the commission has discretion to investigate.
Yeah, how about that? The allegations that the commission has the discretion to investigate. I like that wording.
And maybe in parentheses mention or in a footnote referred to as type 2 and type 3 incidents in the investigations procedure. I don't know if you even want to connect that further.
I'd rather try to avoid connecting things between the procedures so that one gets it modified or whatever.
That the commission has discretion to investigate.
And
Is that
maybe,
accurate?
yeah, maybe in parentheses per the
In accordance with the investigations procedure? Or something
I was
like
saying
that?
I was thinking in accordance with the municipal code section.
Yeah, the
Mm.
ordinance, yeah.
Mhm.
So in accordance with the municipal code section and
I can look up the section and put it
Yeah.
in here.
they just put blank.
Okay.
And
Yeah, but I had basically the same kind of thoughts on this, is that it just needs to be within those criteria that the commission has discretion to investigate. And I think, I guess it more of a kind of, again, looking at it from a practical standpoint. Realistically, probably the cases that come into the commission would need to be reviewed and prioritized for investigation, because at that point, the commission would have a head start on the SOL. And by the time the commission gets a case that has already been reviewed by AA, it's already 3,
Exactly.
4, 5, 6 months into the SOL. So I guess in the discussion or at some point, I guess it would be nice to just kind of explain the intent. It's not for every single case. It's good to have this provision, but again, it will not be feasible for every single case that the commission reviews. Also to be, I guess, in reality, my concern is that then it will be every single case the commission reviews, then we'll try to refer for an investigation, and that can just kind of create kind of gridlock.
And so that's why I worded the way that I did. So it's
Yeah.
clear that if there's not enough time, and oftentimes there's not going to be enough time because we won't review it until IA is done, and there may not be enough time to do an independent investigation. And then the second one is the resources that are currently available and the priority. And so it's up to the discretion of, I mean, the request is made, and then the cabinet discusses it with the chief investigator and executive director and lets the team know whether or not it's feasible or not. And I'm thinking that this would be used rarely, and it probably would be equally as rare that the request would be granted, but it could be significant in some cases.
Is there a provision for the commission by a vote to override this procedure?
No, because it's a procedure that is approved by the city council, and so we can't really But I mean, we could put in there that the commission could override the cabinet.
Right, yeah, that's what I mean.
Um,
Because if the investigator, the chief investigator, the executive director, and the cabinet all decide something should not go forward for investigation, but 3/4 of the commissioners think it should.
but we already have that provision in at the initial, when the case comes in. And so this is really a determination that's made late in the game that we want to perhaps
Yeah, there is no provision like that in the investigations procedure in terms of the commission overruling the cabinet. And I don't recommend creating something now separate like that in the case review procedure.
yeah, I mean, I think we have to trust the cabinet in consultation with the executive director and
Because the staff will have the information. Like again, the on the ground information, what is the workload, what are the number of investigations? To inform the cabinet, and the cabinet hopefully takes that into account. Again, I think I'm concerned if the commission has the ability to overrule that, because that can be also every single case.
Well, at the same time, the Commission on Police Practices is what was created in the interest of and by the vote of the people, not the cabinet, not the investigators, not the staff. That we have been entrusted with and empowered with the power to make the final decision on everything. Just in this way in which we hope to be able to trust our cabinet and our staff to guide us in the right direction and help us make the right decisions. The final decision, it seems to me, should always be up to the commission itself by vote.
I think that could be brought up in closed session by a commissioner, to direct the cabinet to do something.
As long as the final decision, in my opinion, falls on the commission, not a subset of the commission or staff, I'm okay.
There's no such provision in the investigations procedure, so, and, I'm just liking that for you.
Yeah, but I think that the same thing could happen there. That if there is a outcry from the because they're required to report back, and I think it was that if they report back and they have a concern, then at that point in time they could give the feedback that you need to do it.
Right.
Okay.
And again, I feel like certain decisions, if it's always by the vote of the commission, then it can also create a bunch of bureaucratic hurdles.
I'm not saying always, and I'm hoping again that we have mature enough staff, leadership, and commissioners to do this in a mature way. At the same time, if a majority of the commission disagrees with the cabinet and the executive director, I think the responsibility is on the commission to make a final decision. It should be rare.
Yeah, well, and they could also do that when, and it may be late, but when they're voting on the case itself, they could say, we want to refer this for,
right.
We're not going to approve it. We want there to be an investigation.
Right. And I think there's also a provision for, since the commission will be informed of all the potential cases, whether they were accepted or not, there'll be an opportunity for commissioners to bring stuff forward if they choose to.
Absolutely.
Yeah. Okay.
Okay. And according to my watch, it is 7:02, and we're not in a time crunch. And so we will just stop there for tonight, and we'll pick up. I think we should be able to get through the rest of it next time.
Sounds good to me.
Are there any other procedures that you want the committee to think about for the next meeting besides the case review procedure?
I did have a discussion with Andrea St. Julian regarding the procedure for reviewing and evaluating the department's compliance with state, federal, and local reporting requirements. And I can share, so if we have time, I can share her suggestions and get some feedback from the committee as to how to draft that, because I was kind of at a loss. I think I have a better understanding of what they were looking at, what the intent of that was in the ordinance. And so I can, if we have time in 2 weeks, then I will bring up, then we'll put that on the agenda as a preliminary discussion and get feedback from the committee.
Which item is that? Which item are you referring to?
Okay, the commission is required to review and evaluate the department's compliance with all local, state, and federal
Right, okay,
reporting requirements.
right, gotcha.
My question is, what does that mean? What are we supposed to do?
Yeah, okay.
And I do have some input as to what the intent is. So now I better understand that. And so I'll discuss that with the committee. And Andrea also agreed to, after we get something in writing, to look it over to see, give us her feedback as well. And so we'll do that next time, because that'll be our next procedure. And I think it'll be our last procedure, because I think that Janelle was going to work on the one regarding records.
Retention and disposal?
Right.
What about mediation?
Mediation, we decided we're going to defer that one because we're not going to be doing mediation for a while.
Okay.
And so
Okay, I do see the note. Yep, I see the footnote.
we didn't want to hold up the package for that one. And so we will do down the road a separate one for mediation. But we did decide that we wanted to put all of them together in a packet. And
Right.
I forget whether our meeting with employee relations was before or after our last meeting. Wasn't it before, Olga?
Could you say that again? I'm sorry. I was reading the list of the procedures.
Meeting that we had with the employee relations people who do the meeting confirm. Was that before our committee?
I think it was before, because I remember it being mentioned that we need to. put
Right.
something
Yeah,
together
you
in a
briefed
solid
the
package.
committee
Yeah.
Yeah.
after that meeting.
Yeah.
Mhm.
And so anyway, the conclusion there was that we should include all of them.
Right,
And we should put it into one packet. And then in some subsequent discussions with Danelle and the council office staff, and looking at what their calendar is going to be, it doesn't look like they will be able to do it prior to their August recess. And so her suggestion was that rather than try to rush it through the commission and get approval of everything, that we take our time, do it thoroughly, and also would allow time for the new executive director to look them over before we package them and send them on to the city council. So the plan is to have everything packaged together in a final form, approved by the commission and sent to the city council in July or August for consideration by the Public Safety Committee in September. And then after Public Safety previews it, it'll go on to the full council. And I have no idea whether or not they're going to look at it and say, this looks great, and move it on to the council, or whether they're going to have a bunch of questions for us. It's really hard. There are two former deputy city attorneys on that committee.
right.
And so I wouldn't be surprised if we don't have a lot of questions. We have to answer it at that point in time. Oh, and also I might mention that Danelle and the cabinet convinced me to apply to continue for another term until we get this project complete, and then I will resign from the commission, because I initially had made a commitment that I would only serve one term. And so they convinced me to complete this project and then I would resign. And so you're stuck with me probably until the end of the I'm not quite sure what the intent is, whether they want me to go through the meeting, confirm meetings or not. Anyway, you probably are stuck with me for at least another year.
Well, that is some great news. I'm excited.
As long as council agrees to reappoint me, but it doesn't look, it looks like that's a matter of formality. So
It'll be 2 years though, right? Next appointment is 2 years.
2 years. That's what I'm saying is that what I'm agreeing to do is to resign midway through the next one.
Oh.
Okay.
Oh, we'll consider that. That might not
You
be
don't
good.
know, Doug. Maybe you'll get convinced
that-
again to stay through another year.
Yeah, that might not be a good idea to quit in the middle.
Well, they're gonna appoint some, and they can appoint somebody. That's why I'm thinking maybe next June. That way they would appoint it during the normal appointment process. But my initial one, I thought that it was important that we have fresh people serving on the commission, but I thought it was important that we have somebody with some institutional knowledge. And frankly, I think the commission would have been lost without me and Brandon kind of navigating this. And so I put in my initial letter that I would only serve one term. And that would be true to my belief that we need fresh people. And I served on the maximum number of years on the CRB, although the clock technically starts over again. And I was kind of hoping when they drew the names, because who got the 1-year terms and 2-year terms was determined by lot. And so I was kind of hoping I would have 2 years to complete this. And then I 1 year and I go, oh, okay. And so anyway, I think by doing this, we'll be true to the intent of my commitment, but will also serve the commission. So,
Yep.
Okay, so we are for tonight, and I'll see you next week, and I will let Gloria know that we may or may not include the subpoena procedures, depending upon whether we get the answers from Dwayne.
Okay,
Okay, thank you.
Alrighty.
thank you. Have a good evening.
Thank you all. Have a good night. God bless.
Bye.